Kingsburg?
No, not yet.
Sorry, not yet.
Almost.
I don't have Facebook, give her a moment. Technology, our friend.
Sorry, guys.
Okay.
Let me just make sure. Don't think so. Okay, fine.
So I'll open the meeting of the Kingsburg Planning Commission for November 9th. And I'll ask that the meeting be called to order. Please take the roll.
Commissioner Ball,
Here.
Commissioner Kingsbury,
Here.
Commissioner Taylor,
Here.
Commissioner Gonzalez,
Here.
Commissioner Blaney,
Present.
Commissioner Rowe,
Here.
and Chairperson Cooper.
Present. So moving on to the next item on the agenda, which is public comments. Any person may directly address the planning commission at this time on any item on the agenda, any item not on the agenda, or on any item that is within the subject matter jurisdiction of the planning commission, maximum of 5 minutes per speaker. I don't see anybody interested in taking that opportunity. So we'll close that, move on to item number 3, which is Brown Act training, our annual Brown Act training, and I'm going to pass it over to our city attorney, Mike Nolan.
Thank you, Mr. Chairman, and members of the commission. I have 2 disclosures I need to make to you before we begin this. Number 1, this is the first PowerPoint I've ever done. And number,
Congratulations.
yeah, I know. I'm going to have to tell my kids. And number 2, this program was put together with my partner, Mr. Google, and some other city attorneys who have worked diligently to identify some of these issues. So now that we've gone through that, we're going to talk about the Brown Act and also the conduct of public hearings. And I know the packet and the PowerPoint seems to be a little thick. We'll go through this quickly. Many of you know much about what we're going to talk about today, and so it's more of just a refresher. There have been some changes that went into effect this year with regards to certain issues involving the Brown Act, and we'll cover those also. But the Brown Act is the act that controls how this commission and the City Council and other jurisdictions other than the state of California in the conduct of its meetings and the requirements that we have to satisfy in order to make sure that those meetings are conducted properly. Just at the beginning, this handout does not include any information regarding the Brown Act as it relates to closed session. In my tenure here at the city, I think we've had closed session with the Planning Commission once. And so if it comes up to a situation where there's going to be a need for a closed session, we'll go over that with the commission prior to the closed session. Closed sessions relate specifically to transactions involving the sale of real property, litigation, if the commission or any of the members of the commission are named in any litigation, personnel matters and things of that nature. So they're really not matters that in the normal course come up before the planning agency of the city, which is the Planning Commission. Let's go this way. Okay. Who is governed by the Planning Commission, by the Brown Act, are all legislative bodies that must conduct their business only within public meetings. And so you cannot conduct your business other than in public meetings so that you have the opportunity, so that the public has the opportunity to listen and watch and understand the activities of the Planning Commission and its members. What is a meeting? A meeting is a congregation of a majority of the Planning Commission to hear, discuss, and deliberate and take action on items within the subject matter jurisdiction of the Commission. And it's the use of a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, and take action on any item of business within the jurisdiction of the Planning Commission. When we talk about communications, though, we have to not be involved with any serial meetings, which are a chain of communications, each of which involves, less than a quorum of the legislative body, but which together involve a majority of the body. So that, in essence, means your communications between each of you, which ends up with a decision or with information between all of you, that between five of you, which is a quorum of the commission, such as using emails, talking on the telephone, texting, using social media, any type of communication which creates an opportunity for a quorum of you to discuss issues that will come before the commission, or which are within the subject matter jurisdiction of the Planning Commission. And this also includes communications if you are having communications with staff, and then you start communicating between yourselves, taking into consideration what you talked about with the staff member. And so again, because of our electronic communications that we have now, anything that deals with your communications between all of you or between a quorum of you could result in a violation of the Brown Act. City attorneys hate email, and because email never goes away, you can create a virtual series of meetings, and so it always makes us nervous when people start using their texts or their phones or their emails to communicate with each other. The other thing you have to remember is that under certain circumstances, and it gets broader and broader all the time, that your emails or text messages may be subject to the Public Records Act if there's a request made. And so that's another issue that we can talk about at a later time, but it does affect every commission, every planning commissioner, the city council members, and even members of standing committees. And so we just have to be very careful when you're using email or your phones for purposes of communication. And my recommendation to you is that other than communicating about things that don't have anything to do with the Planning Commission or your jurisdiction, that you not communicate using other forms of communication other than being here at the meeting or talking with staff. What starts out as legal under the Brown Act sometimes becomes illegal when it is replied to by a majority of the planning commissioners. So again, in your email, if somebody sends out an email and they send it out to everybody, and everybody replies by saying, I agree, I concur, or it's a good idea, and 5 of you do that, that constitutes a serial meeting and would be in violation of the Brown Act. And again, when we talk about any type of internet communications or social media, that lends itself to the potential of serial meetings and violations of the Act. And again, we emphasize this just because of the way we communicate now, and it's so easy to do this and to just find out what one of you thinks about an item that's coming up on the agenda at the next Planning Commission meeting, and then you say, well, how about what does so and so think, and what does so and so think, and all of a sudden we've got an email chain or a text chain of 5 of you talking about the matter that's coming up before the commission at the next planning commission meeting. Effective January 1 of 2021, simply posting general city information without personal opinion or comment is probably okay. Any social media communication with other officials about issues related to matters under the body's jurisdiction violates the Brown Act. And so even postings or commenting using digital icons or things of that nature is prohibited. So if you're doing texting and you send one of these, and 5 of you send one of these, thumbs up, that could be a serial meeting. Or you send a smiley, that could constitute a serial meeting. So we just need to be careful about that. Now, there are a few exceptions to the Brown Act. Individual contacts between, or conversations between members of the legislative body or other persons that don't really involve or within their jurisdiction. If you go to this, a planning commissioners conference, things of that nature, those are exempt. Again, but you really, 5 of you, if 5 of you go to the planning commissioners conference put on by the League of Cities, and you sit down together and go to dinner and talk about items that are within your subject matter jurisdiction or items that are coming up before the planning commission or may come up before the planning commission, that could constitute a violation of the Brown Act. So you just need to talk about your grandchildren or kids or things of that nature when you go to dinner. And in going to public and community meetings to discuss a topic of local community concern, again, that's not within the jurisdiction of the Planning Commission or that's not potentially coming up before the Planning Commission are okay. But if a group of people, if we're looking at having the general plan, the new housing element coming up before the Planning Commission, and the Tuesday, was it the Tuesday Club or the Tuesday Morning Club or the Tuesday Afternoon Club, has a meeting about talking about housing in Kingsburg, and they open that up to the public, my recommendation is don't go, because those issues are going to be coming up before the Planning Commission and are within the subject matter jurisdiction. But if it's other community meetings, such as having the people running for Congress coming here to speak, and the League of Women Voters puts that on, or some other organization, you can go to those. You can also go to other legislative bodies that are open to the public, like the Board of Supervisors meetings. You can go to those. Standing committees like we have here in the city, the Community Development Commission or Finance Committee or things of that nature, you can also go to those provided that you're not a member of the standing committee. And then, of course, social and community meetings and events. The notice requirements for the act are basically for staff to be concerned with. The agenda has to be posted 72 hours before the meeting, and the agenda, as they do, contains a brief description of what's going to be handled in the meeting. The significance of that is that you can't talk about anything related to the subject matter jurisdiction of the commission that's not on the agenda. And so you can't just bring up issues to talk about, before adjourning the meeting or things of that nature. They have to be on the agenda. The Brown Act does make provision for adding things to the agenda if that becomes necessary, but it has to deal with a matter that has to be decided before your next meeting, and it has to be placed on the agenda by a vote of 2/3 of the Planning Commission in order to put it on the agenda. And so there are opportunities to do that, but they're few and far between. You can also have special meetings and then emergency meetings. And the special meetings are posted 24 hours before the meeting. And again, it has to deal with business that cannot be conducted at a regular meeting, and must be conducted between now and the next regular meeting. And again, if need be, we can have emergency meetings with 1 hour's notice. On non-agenda items, as I mentioned, the legislative members of the commission may briefly respond to questions or comments from the public. They may ask questions for clarification from staff and may provide a reference to staff or elsewhere for factual information. So you can ask questions. You can talk about, respond to questions and comments by the public. We usually recommend that you don't respond to public comment if somebody comes in and starts asking you questions about different things that are within their subject matter jurisdiction. Normally, we recommend that be turned over to staff, and then staff can communicate with the member of the public as to those items that they have a concern with. These are just statutory exceptions to the agenda. As I mentioned in the second item, is a subsequent need item, which is requiring immediate action that comes to the attention of the commission after the agenda is posted and requires a 2/3 vote. And when we do that, not only do we have to vote to put it on the agenda, but we also have to vote to that the matter has to be decided at this meeting, and it cannot wait until the next meeting. And then holdover items from previous meetings. The agenda description, again, it's basically up to staff, and staff does a very good job of preparing the agendas and satisfying all of the requirements of the Brown Act as when they put those together and post and send those out. As the chairman did this evening, at every meeting you must have public must have an opportunity to comment. And they address the legislative body concerning items of interest to the public within the subject matter jurisdiction of the city. We usually provide that those are items that are not on the agenda, because this commission and also the city council allows members of the public to speak on items that are on the agenda, even though they may not be public hearing items. But it must occur before you take action, just in case somebody wants to talk about that. So we can't have public comment at the end of the agenda. It must always be at the beginning of the agenda. I've been involved in other jurisdictions where they have it at the beginning and the end, but that seems a little redundant. And if you're having a special meeting, the public, it's different, and then the public can only speak to the address items that are in the notice that are on the agenda for the special meeting. With regard to public comment, when a person comes up to the podium, we may request that they identify themselves when speaking. And some jurisdictions use request cards. We can't require them to say where they live, whether or not they're citizens of the city of Kingsburg or that sort of thing. Technically, most people do, but technically we can't ask those questions. People are allowed, unless there are findings otherwise, to record the meetings, to take photos at the meeting, so long as it's not disruptive. And we can also limit the amount of time that someone speaks during public comment. But we have to provide at least twice as much allotted time for a person who's a non-English speaker who utilizes a translator. And in public hearings, as we'll talk about, you can also limit the times that they speak during public hearings.
Question.
Yes, sir.
So any person that gets up to speak, it does not have to identify themselves? They can if they wish.
Theoretically, I think legally they don't have to do that. but we have a right to ask them. We have a right to ask them, but we can't force them to do that. We also, there are issues with regards to disorderly conduct. We can stop the meeting, we can clear the room, and then continue the meeting after. And then we have rules of decorum. The chairman is in charge of that, and basically that is an assumed responsibility and right of the chairman to conduct the meetings in an orderly fashion and not allow people to be disorderly and take up too much time. Votes are always by voice vote. We don't do secret ballots under the Brown Act. Any documents provided to you are public records. They must be provided and given up and provided to the public. Nowadays, we must post them on the city website and provide a reasonable number of copies here at the meeting so that people can have them when they walk in the door. If there is an inadvertent error in conducting the meeting or something of that nature that may be a violation of the act, it can be cured or fixed, and the cure is not admissible in evidence in any civil or criminal action. But the city can, miss a critical deadline regarding the curing of that. The curing must take place as quickly as possible once we recognize that there is a violation, and we must take the appropriate steps to cure the violation and to remedy it by the appropriate action to be taken by the commission. The Court of Appeals has held that cease and desist procedures, if an action is filed against, if we do something in violation of the Brown Act and a cease and desist action is brought against us to cure or correct it, it is not applicable to the alleged ongoing future violations, only to the violation that had occurred. So if we determine that we have had a violation, the main issue is to get it cured and corrected as quickly as possible. If there are violations of the Brown Act, there are enforcement actions under the Act, both from a criminal standpoint and a civil standpoint. If a legislative member who attends a meeting in violation of the Brown Act is guilty of a misdemeanor, if action is taken by the legislative body, an actual vote is taken, and the member intends to deprive the public of information to which the member knows or has a reason to know the public is entitled. So if under a criminal prosecution, those are the conditions that would have to be established and proven in order to be guilty of a misdemeanor for a violation of the Brown Act. And then we also have civil actions. Enforcement actions can be brought by the district attorney or any other interested person to get the court to order the stopping of any violations of the Act. And that's normally the way that it occurs, is that there's a civil action either brought by the district attorney's office on a complaint by a person or members of the body that is subject to the Brown Act, claiming that one of its members have violated the Act. And there are certain requirements that can be done, such as someone can seek the court order requiring the legislative body to tape record its closed sessions. And many times that's when these types of actions will come about, is when there is a claim made that either the closed session was improperly held, it was improperly noticed, or that it dealt with issues that are not within the confines of the closed session requirements, or that somebody on the legislative body has disclosed closed session conversations outside of the closed session. And that also constitutes a violation of the Brown Act, is to disclose those statements outside of the closed session. And so injunctions or writs of mandate are usually the proper civil enforcement actions that are brought. Let me go. I got the, when we sent this over, the updates to the Brown Act are put at the end of the public hearing information. So we'll do those at the end. But are there any questions with regards to what we've gone over so far in the Brown Act? I know I've gone through it quickly, and you can review the document that you have in front of you, and certainly contact me if you have any questions with regards to any of those procedures and the applicability of the Brown Act to what the agency is doing. The main thing, I think, with regards to the Planning Commission is making sure that you don't get involved in serial meetings and things of that nature. That's the most, I think, the most relevant part of the Brown Act for you, because all of the meetings will be conducted in accordance with the Brown Act. And like I said previously, it's unlikely we'll have a closed session with the Planning Commission unless somebody really gets mad at you. So, okay.
Question. Could we get a copy of your excellent PowerPoint presentation?
Yeah, we'll have copies for all of you.
We'll get that to you on Monday.
All right.
Yeah,
That's all right. Then we'll get you a PDF.
right. Now, let's talk about public hearings, because that always becomes sometimes an issue. And public hearings are held as required by law, pursuant to certain provisions of the government code. With regard to the Planning Commission, your public hearings normally will relate to land use items, because you're the planning agency for the city. So tentative maps, general plan amendments, zoning changes, conditional use permits, all those land use types of actions are subject to public hearings. And staff has to do the necessary postings to publish those public hearings in the newspaper of general circulation, and also send out notices of the public hearings to people living within either 300 or 500 feet of the boundary line of the property which is subject to the public hearing. And as set forth on your agendas, when the sequence of the public hearing is first to open the public hearing, that the chairman does, and then the second is to address any recusals, any conflicts of interests that anybody may have, and we'll go over that in just a minute. Then we have staff's presentation of the item, the opportunity for you to ask factual questions of staff and get clarification from staff on the matter. Then we open up the public hearing to public comment. Then we can close the public comment and receive testimony. Then we close the public comment portion. If you have any other additional questions of staff, and then we close the public hearing. And I've got these a little bit out of sequence because I like doing it a little bit differently than some jurisdictions do, because I think that it's important that we open the public hearing at the very beginning from a litigation standpoint, so everything that is said with regard to the agenda item is said during the public hearing, and that we only close the public hearing after all of the questions have been asked and answered, and the commission or the city council is ready to make their decision. Now, what do we, let me see. Recusals come first, and a recusal is if you have a conflict of interest in an item that comes before the Planning Commission. And many times, well, usually that's a result of either having an issue that is a conflict under the Fair Political Practices Act. And if you have a conflict, and we'll go over those in a minute, you cannot participate in the item before the Planning Commission. You must recuse yourself and make the recusal on the record. You need to state the reasons why you're recusing yourself, and then you need to leave the room. You can't sit in the audience. So, and when do you have a conflict? Again, there are many ways, but under the Fair Political Practices Act, the main issue is if you have a financial interest in the matter before the legislative body. And one of the common examples is owning property within 500 feet of the area subject to the body's decision. So if if you're considering a conditional use permit for a piece of property and you live within 500 feet of the property, or you own property within 500 feet of the property, even though you don't live there, then you may have to recuse yourself. And when we talk about financial interest, it's not only your financial interest, it's financial interest of your spouse, your children, members of your family that could have an effect on your ability to be independent and make an independent decision with regards to the matter that's before you. If you think that there may be a conflict, you can always contact me and we will discuss it, and you'll find that I'm very conservative with regards to these types of matters, and even if could be an appearance of conflict, even though there may not be a legal conflict, usually my recommendation to you is to recuse yourself and not be involved in the decisions to be made by the jurisdiction, by the Planning Commission. But my recommendation is set forth here, don't wait till the last minute. Once you see the agenda and you think that there's a conflict and we need to talk about it, we don't want to try to make that decision 2 minutes before the Planning Commission begins its meeting. And you can always call the FPPC and talk with them and get direction from them on the conflict. The parliamentary procedures for the public hearings. Some of the major mistakes that can be made is a commissioner expresses an opinion prior to commencement of the hearing. And not only an opinion at the meeting, but an opinion outside of the meeting. If you're talking with a friend on the street and you tell them, well, this is a bad project that's coming before us at the Planning Commission on next Thursday night, that's a problem if somebody raises that issue during public comment. If your friend comes in and says, oh, we talked about this out on the street. If you debate with speakers, we're here to get the staff report, get the facts associated with the matter before you, to ask questions, factual questions dealing with the project or the matter before you, but not getting into a debate with the applicant or any persons who are opposing the application, but to make the factual determinations you need to make in accordance with the municipal code and state law. And then after a closed public hearing, members raise issues or facts not presented at the hearing without the Planning Commission reopening the public hearing. So once we close the public hearing, that stops any further facts and information to come before you in order to make your decision. But if you let someone come up again and want to speak to the issue again, and you want to allow them to do that, you have to reopen the public hearing, take that testimony, then close the public hearing again. Issues of due process, and I've talked about this before, but these are the issues where you have contact with developers or citizens or others who want to talk with you about a project that's coming before the Planning Commission, or an item that's coming before the Planning Commission. My recommendation always, again, I'm very conservative when it comes to this, is don't talk to them. Avoid the invitation. If you're contacted, be polite, but avoid stating a viewpoint. If you do speak with someone about a matter that comes within your jurisdiction that you're going to hear at a public hearing, you have to disclose that discussion before and enter it on the record at the time that after the public hearing is opened. So if you talk with a developer about a project that's coming before the Planning Commission, they come to want to talk with you about it and express to you the benefits of the project, and you make the decision to speak with them, or you meet with a group who's opposed to the project and you agree to speak with them about that, you have to disclose all of that. You have to disclose who you talked with and what the content of the conversation in the meeting was. And you do that after the public hearing is open. And so my recommendation to you is to not do that, because it sometimes is uncomfortable to have to make those disclosures before the public, especially if it is a fairly controversial issue that comes before the Planning Commission. As you do now, all of your actions are done by making a motion to approve a resolution or those sorts of things. You don't deal with ordinances that much, but other actions or recommendations that you're making to the City Council, if you're amending the housing element or the general plan or doing a rezoning, the motions, have to be approved by we have to have a quorum, and it has to be approved by a majority vote, and we just basically follow the rules of Robert's Rules of Order with regards to withdrawing motions or seeking reconsideration. The chairman may make a motion only after all members have had an opportunity to make the motion, and nobody has made a motion to either approve or disapprove the item before the Planning Commission. So Paul does have an opportunity to do that if nobody else decides to do that, to make a motion. Motions may be on the floor, may be amended at any time before adoption or rejection or denial. Amendments to the motion shall be voted first, and the main motion voted on. And then there's substitute motions, where a motion to amend seeks to retain the basic motion on the floor but modify it in some way. Mostly, though, we're either going to make a motion and then there's going to be discussion, and somebody may want to amend that motion, and you have to vote to amend the motion before you vote for the motion. Under common actions, when we're dealing with, you deal with two different types of decisions and actions by the Planning Commission. You deal with legislative acts, like general plan amendments or rezonings, and then you act as a quasi-judicial body when you're dealing with approval of subdivision maps, of conditional use permits and things of that nature, where you have to make findings to support your decisions, both from the standpoint of environmental review and also from the standpoint of the project before you. And you've done it before, and you'll see that if we have, for instance, a tentative map before you, you will have two decisions to make. You'll have an environmental decision to make on the environmental document, whether it's a negative declaration, a mitigated negative declaration, or on an environmental impact report, and then you'll have the land use decision to make on the tentative map, for instance. You always have to make the environmental decision first on the agenda, and then you make the decision on the land use issue. And and then when you're acting as a quasi-judicial agency, you have to make findings to support your decisions. Because then when the matter is litigated, and we have to submit the record, the court will look at those findings to make a determination as to whether or not there's facts sufficient to make those findings. And that's one of the issues you always have to be aware of, is that when you're making decisions and making findings, when you're dealing on a quasi-judicial basis, the findings have to be supported by the evidence that's submitted at the public hearing. It can't be things that you heard about out on the street unless you disclose that information during the public hearing, so all of the planning commissioners have the same information, because all of you are supposed to have the same information when you make your decisions with regards to the matters before you. So if we have a finding that needs to be made, there has to be evidence submitted in the public hearing record, whether it's in the staff report or in the testimony before the Planning Commission, in order to support those findings. And then your motions are made based upon those findings. If a motion is made to reject certain findings, saying we can't, we have a conditional use permit and it has a list of findings we need to make and we cannot make those findings, again, you have to recite on the record why you can't make those findings and the evidence which supports your decision that you can't make those findings. So you've done it before, but that's just a reminder that because litigation is based upon our failure to have evidence to support the decisions that we made, whether it's the environmental decision or the land use decision. So, and if it's on a controversial issue, many times it's the environmental decision that subjects the city to litigation as opposed to the land use decision. Voting is roll call vote again. If you abstain as a result of a conflict, for purposes of the item under consideration, if you abstain from voting, you're not considered for purposes of a quorum. So if we only have 5 commissioners one evening and one commissioner abstains from the vote, you don't have a quorum. So you can't carry on your voting. And if you abstain, you need to recite on the record why you're abstaining. You can't just say, I'm abstaining. Also, if you have a tie vote, that's a denial. We always try to have affirmative votes. And best practices, think fairness, merit-based decisions, making your decisions, and keep politics separate and all those funny things that we have to think about. But those are in a nutshell, how we conduct our public hearings, and just a refresher on how those are held.
I have a question.
Yes, sir.
So, when we're required to make land use decisions and approve a map or whatever comes in front of us, I've never been real comfortable with being a quasi-judicial, in a decision to make quasi-judicial decisions, because I'm not an attorney. I don't feel qualified to make decisions of law. And I'm trying to think back. We always get a staff report for these land use decisions with recommendations from the staff on which way we should go. But I don't remember ever getting a legal recommendation on whether the issue before us complies with all of the laws, state and municipal laws. I don't remember ever getting a legal decision on whether that issue has been reviewed and complies with all the laws. We get a staff report, but the staff report usually doesn't deal with the legal issue and whether it complies with the laws. They don't go that far. So am I wrong? I just don't remember. I'd feel more comfortable if there was a legal, as part of the staff report, there was a legal declaration from the legal department that it's been reviewed and all of it complies with the law. We can go ahead and approve it. Am I wrong on that?
Yeah, when we talk about a quasi-judicial action, what that means is it means that the decision that you make, the decision that you make has to be based upon the facts that are submitted to you during the public hearing. Staff, if staff will confirm through the staff report that the applicant has satisfied all of the requirements in the municipal code and in the government code in order to have the, let's just talk about application for a tentative map, to have the application for the tentative map, they've completed it, it's been approved, they've submitted everything, and now it comes before the commission. So staff is saying from the standpoint of, from the legal standpoint, that the subdivision, that the application and the tentative map satisfies everything that needs to be done under the municipal code and under the government code as it relates to the application for a tentative map. It comes to you for purposes of approving the tentative map. And the staff report, again, with part of the evidence that's being submitted to you for that tentative map is the information in the staff report that says the application is complete, it has been made, it satisfies all of the municipal code requirements, it satisfies the government code requirements for a tentative map. We have properly noticed the public hearing as required by the government code, and so it now comes before you to determine whether or not the subdivision, the tentative map, should be approved. And if you look at the staff report and the developer comes up and says, you know, we've satisfied everything, the lots are all 7,000 square feet or larger, we're going to put the park in, and staff has said to you, we've reviewed the subdivision map, we've done an initial environmental study, and based upon that initial environmental study, we've determined that a negative declaration can be issued for this project. That gives you then the evidence and to make the findings that the application and the tentative map satisfies all the requirements from an environmental standpoint and from a land use standpoint and should be approved. Now, if somebody comes in and says, testifies against that and says staff's analysis of the environmental aspects of the project are inadequate, that their initial study is inadequate because there was no traffic study done, and this project is going to generate 1,000 trips a day, and that wasn't considered by staff, then that's evidence that you need to consider as the quasi-judicial body, meaning that you're looking to evidence to support your decision. You take that into consideration in making the determination as to whether or not it's the staff's recommendation of a negative declaration is correct. And so you would ask staff about that, staff would respond to that, and then that's part of your decision is based upon the evidence that's being submitted. Is a traffic study necessary? So you would send it back. Or is that traffic going to be so much that we don't agree that a negative declaration can be issued for this subdivision? And because the facts before you support a decision to deny the negative declaration. So it's not your decisions and these sorts of things are not subject to a legal opinion from the city attorney every time a subdivision map application comes up. If there are legal issues, I'm confident, and we have done it before, that Holly's going to get a hold of me, or Alex is going to get whatever the case may be, and we go through those legal issues and we try to get those resolved before it ever comes to you, so that there aren't those issues. And if it's a controversial issue, and especially from an environmental standpoint, we try to address those as best we can. My hope when I sit in the Planning Commission or City Council is I don't have to say anything, because everything's done ahead of time. And so But yeah, it doesn't involve a legal opinion. What it involves as a quasi-judicial body is you making decisions that are supported by the evidence that's submitted in the staff report and any other written documentation submitted into the record and any and all oral testimony that's given to you. And the questions that you ask of staff and of the applicant and of the opponents, and getting that information which you are then considering in making your determination whether or not to approve or deny the project.
Okay.
And if there are legal issues that I think should be considered by you, then I'll bring those up as part of the evidence that you'll consider at the public hearing.
Okay.
Okay. Just some updates on the Brown Act, just briefly, is that with COVID, we were able to change our hearing procedures so that all of you could Zoom into the meetings, and we could have the Zoom Planning Commission meetings and the Zoom City Council meetings and that sort of thing. And that was allowed, but now, as a result of the governor announcing that the COVID state of emergency ended February 28th of 2023, we cannot now hold those types of meetings, Zoom meetings, anymore, except there has been legislation passed that under AB 2449 that allows you to participate by way of Zoom if you satisfy certain issues, including illness or illness of a family or things of that nature. So they've created a new way for you to participate if you can satisfy certain requirements, and that's new starting this year. The Brown Act does provide general provisions for participating in a meeting when you're not present here, but you're someplace else. But that requires being at a place where the public has an opportunity to come and sit next to you wherever you are. For instance, that if you couldn't come to the meeting and you were home, then the agenda would be set up in that fashion, and you would have to open your home to allow the public to come and sit with you in your living room while you participated in the meeting. Okay. So, but we can no longer hold those COVID Zoom meetings anymore. And then there are some further changes and they're minor changes dealing with having copies of the agendas available to the public and providing a little bit more strong language by allowing the chairman of the Planning Commission or the mayor to deal with disruptive people in the meetings. Puts a little bit more teeth into that. But they're just minor changes to the Brown Act, and they'll be part of the handout that you get on Monday. Any other questions? Well, I appreciate the opportunity to come and make this presentation to you. And again, if you ever have any questions about the Brown Act or about public hearings or about any issue with regards to your participation as a member of the Planning Commission, please don't hesitate to give me a call or send me an email, just between the two of us, not anybody else, and we'll be happy to respond to any questions that you have. Thank you.
All right, thank you for that. We'll move on to item 4, consideration of request for residential housing units from the annual allocation under Kingsburg Growth Management System. And I'm going to turn this section over to Ellie for more discussion.
Chairman Cooper, would you prefer that we take a little bit of a break, or would you just like to roll into this? I just wanted to give people the opportunity if they feel like they need to get up and stretch a little bit.
Break, raise your hand.
No break?
Yes,
All right.
Motion on through.
We are rolling on then. Thank you. Good evening, planning commissioners and Chair Kruper. We're Holly Owen, Community Development Director. We're here tonight to consider awarding a competitive housing unit allocations for residential development for 2023. In accordance with the provisions of the section that guides this action, Section 1609060, we will be considering to take the following actions: review the rating and ranking for competitive housing unit allocations for the residential housing units for the proposed development project identified below for the 2023 housing unit allocations. Single-family development, West Star Construction being the applicant on 18.85 acres, northwest corner of Mendocino and Solig Avenues, and 14.42 acres west of Mendocino, north of Cam, south of Carruthers Avenue, to develop single-family residential lots for custom home construction for a total of 105 single-family residential housing units. And that the Planning Commission passed Resolution 2023-03 recommending to the Kingsburg City Council the approval of the allocation of 105 single-family residential units for the 2023 calendar year pursuant to the Kingsburg Growth Allocation Program. Just to summarize, for those who may have be new to Kingsburg or new to this process, the growth management system was a ballot measure passed by Kingsburg residents in November of 2004. It was a result of concerns at that time regarding unplanned and uncoordinated growth in the city. And the growth management system provides for 115 housing unit allocations to be made available at the beginning of each calendar year, with a potential 2 rounds of applications for housing unit allocations per year. And then during a time where there was a downturn in the market, annual allocations had continued to accrue, and it resulted in a resolution that was passed by City Council allowing the units to accumulate for a period of 3 years. As described in the appropriate section, the applicant submits on a date certain if they want to be considered for housing unit allocations. Part of that application process is to review their own project and to rank it according to the criteria that is actually in the ordinance, and they calculate this on the use of a 100-point scoring system, and then the Planning Commission is required to review that rating and ranking recommendations prepared by staff. So staff reviews that internally, looks at the criteria, and looks at the application. And that is attached as your packet C, where staff has reviewed the single submittal that we had this year, and we have we've made our determinations and our recommendation to you. So the proposed development project is in the North Kingsburg specific plan. It will be processed as a planned unit development. It's subject to the design standards and all the other requirements that are found in the North Kingsburg specific plan. This land also needs to be annexed, so they have a little bit of a longer time frame in which to realize their project. The allocation of the housing units to this project, however, is not an approval of the project. It's not an approval of the map. It is a consideration to allow them to continue the process for eventually applying for the building permits that they need. So this is not a new, this particular application came to you last year in a different form. There was a different property owner at the time, but now it has been consolidated, and it moves forward as one project under one owner. In terms of the environmental review, it is not considered a project, so there is not a CEQA It is not a project under the California Environmental Quality Act, and therefore, that is the environmental determination. And the recommendation also is that the Planning Commission award the 105 housing units for this particular project. There is a copy of the ordinance that was recently revised, or I would say clarified in terms of verbiage, and that is included in your packet. There are elevations that are conceptual at this point, but also were presented as part of the packet. And then there is the resolution that you need to consider and act upon tonight. That concludes my staff report. I'm available to answer any questions. And I think I know for a lot of you, you've been through this process before, but it's a little bit nuanced. So if there's anything you need to want to review at this point, you can. The attachment C, which is the staff's ranking, pretty much parallels what the applicant submitted. So, thank you. Mr. Blaine?
In looking at the proposed map, I noticed that the first street to the south is Carnation. The next street is an E Street, Evergreen. Should that not be a D street? With our standard of going ahead and naming all the streets north of, what's the A street? Azalea? Should be Azalea, should be an A, should be a B, should be a C, a D, and they're all supposed to be flowers, if I remember correctly. Evergreen is not a flower, I don't think. And it's also not a D.
It's an attribute. It's not a flower, I believe. Yes, yes.
So I would strongly suggest that the applicant go ahead and make those changes.
That is duly noted. The applicant is here tonight to speak not only perhaps to that request, but also to the project in general and to answer any questions. And so the applicant's representative, I'm sure, would take this opportunity to do that, should that be their desire. I appreciate your input in street naming. We've actually had internal discussions about street naming. For those of us who are a little bit newer to the city in terms of the naming process, I know there has been guidance given by previous councils and planning commission in that regard.
Was specific so that it makes much more sense for those of us who have to negotiate the streets of Kingsburg rather than the street over in Pheasant Grove. It is on the corner of E and E.
Yes. I understand.
Thank you.
What's
Thank
the name
you.
of the street that's north of Evergreen?
Street.
That,
It's unnamed.
okay,
That's not,
so that can be Evergreen now.
Carol, is there a microphone for if the applicant wishes to make some comments? That's.
I have a question for you in looking at the elevations, because this is a continuation basically of the project that you've already started. We're doing separate phases of it. How much differentiation do you have between the elevations that have already been completed and what's being proposed for this new project?
Thank you, Sandra Stats, West Star Construction. Thank you for having us. Elevations, I have approximately 518 variations of the project. What our process is that it's each homes are not allowed to have the same elevation or color constitution. They have a process of coming through the city. The staff reviews them. We have site plans to give us a good variety and diversity on it. As the phases progress, we take a look at the current color palettes. We might freshen them up. We might take certain elevations out and then place other elevations in. You might find that as we started with phase 1, you had more of an earth tony colors. Phase 2 has much more vibrant grays. And then phase 3, you're actually getting pretty bold with some blacks. So,
Got it.
and I'm sorry, I hope that's somewhat
I'm kind of
direction.
going back through, because I look at it, and it looks like there's 9 different elevations with 3 different variations of each, so we're looking at 27 different options. But how does that, what, I guess my concern would be that going cookie cutter from one neighborhood to the next neighborhood to the next neighborhood, just changing the box colors as opposed to getting some kind of variation.
With each phase, we've added or changed floor plans. We also allow the floor plans to change. We added what we called our Royal, which was a little bit of a larger home, an L-shaped, took advantage of a larger back. We also, with phase 4, will be actually adding an additional plan, changing up those floor plans. So I see where you're getting from as far as being able to have a different home as itself. So through the process of each phase, we have engaged and changed up actual homes. So if a home is not selling, let's say for instance, a smaller home, we want to keep the smaller homes in our palette or in our toolbox because there is need for that. But as we progress, we listen to our clients, and they might want larger 2 stories. So we will redesign or have those plans submitted. But through each phase, we have changed and brought in and taken out from
Okay.
those points.
And then as these lots are being sold, I mean, I think they're basically being pre-sold, right?
That's
So that you-
correct.
Okay. So how do you separate if they take Plan A and the next person comes in and buys the lot next to them and wants to do Plan A? Do you allow that, or is there?
No, what happens is, and essentially, we have a VIP list, we have that we send out, okay, these next 4 lots are available as the sales compress. It's first come, first serve. And we know those 4 lots will have A, B, C, and D. So if the first person that comes in, they want A's pretty much set off to the side, and the next 3 lots are B, C, and D. So that's how that's done.
So it's a rotating pattern throughout the subdivision?
There's a rotating pattern. It may not be A, B, C, D. It could be A, D, C, E, or however.
Right,
Yeah.
but there's a provision that the same house isn't built next to this.
The same elevations, the same, so you're not gonna drive down the street and say, oh, that's the same house, you know.
Yeah, just a
and then-
different color, but the
Yeah.
same elevation.
Yeah.
Okay, thank you.
And that all goes through the staff too, so just, any other questions? I thank you for the
In this
time.
area, there's only one entrance and one exit.
Yes, we have, heading south, and I wanna say that's 14th, and then exit on 18th, but we also do set stub streets to the north. Always progression and having something for the future.
Thank you. Holly, has there been any other allocations going out for 2023, or is this the first one?
No, this is it,
The one and
at
only?
this point, yes. Mhm.
No.
City council will have an opportunity to, if they so choose, reopen for a, second round of allocations. But, we are at this point still in discussions about the concept of rolling allocations and how much we'll be continuing that in the future. Right now, it's still, there's still allocations remaining. We would like to make sure that if there's a multifamily housing, for instance, that we want to have allocations to consider giving them if the project that seems applicable comes to us.
Educate me a little bit. What is the connection between the points and the allocation for the number of housing units? I know that this was originally set up as a competitive design when we had 5 or 6 developers all wanting to come in at the same time, and there wasn't enough allocations to fulfill all their needs. So we set up this competitive process, which isn't isn't in existence now, this day, because we only got one project, so. And for this particular project, because it's the only one, there is no competition here, explain the connection between the awarding of points and the granting of the 105 allocations that they want.
Okay. Thank you. The allocations, the allocations were the ones that were in the application originally, the 105 units. So that's how that number was arrived at. And the ranking and rating is fairly specific to the ordinance, including points and categories and how staff needs to review them and award them appropriately. We have had in the past some applications that were a little more competitive just because there were other developers. The market has softened a bit. I think we all can agree that it's still active, but not. We've seen them come and go, and at this point, it's a little slower. But I think the purpose of that ranking and rating really is just to flesh out for the public and for Planning Commission and Council, how the applicant is describing their project and holding them up to a certain standard. I will say that one of the issues that I have in this is that there's a whole section on inclusionary housing that for as many years as I've known has not been anything that has been included in a project. So the awards have been zero. And I think it would be useful for us to consider whether or not we want to perhaps change the language to more accurately reflect what may be possible when it comes to creating incentives for a mix of housing within a subdivision or residential neighborhood. But that's a larger topic, and at this point, that's the criteria that were set back when this ordinance was given a little more scrutiny. When the ballot measure passed, it was pretty vague as to how to actually implement this. So the whole process of implementation took a number of meetings by Planning Commission and Council a number of years ago to set up this process.
Okay, thank you. So I guess in my mind, I'm trying to get this straight for the benefit of the Planning Commission. I'll share this. Because there's no competition here right now, the granting of points probably isn't going to have much to do with the granting of the 105 units. But this allocation process opens the door for discussion on this particular project and any other project that comes forward. And that's actually more important than the granting of the points in my mind. So let's move forward with the granting of the points and the discussion that we got from the staff report on to why the points were granted. You've already talked about inclusionary housing, very good topic. There is a section in here I want to read. Where is it here? Yeah, here it is. This staff report. This has been a consistent 0 points. That's the inclusionary housing. This has been a consistent 0 points for most of the allocation applications that the city has reviewed over the last few years. It may be time to alter the criteria to reflect what might be more achievable with current building and financing practices. This would require an ordinance amendment to give guidance to project developers and staff to change this criteria. So, yeah, the point's been made. The exclusionary housing is just not popular at all. The points for exclusionary housing has not been popular to any of the developments that's come forward in the past few years. They're not interested in it. They're not trying to get those points. Even when there was a stiff competition, remember years ago we had like 5 or 6 projects coming in, nobody was interested in getting those particular points. They have no interest in those inclusionary housing. And I'm glad the mayor's here because we can make that point now that following up on the staff report, I think it should be discussed. We can't discuss it here. It would take all night to discuss it here, but the inclusionary housing points, they're not interested in. They're not interested in getting them. So we're going, and the whole object of the inclusionary housing was to try and prompt the developers to put in some multifamily housing, maybe a few apartments, a couple of duplexes or triplexes. They wanted nothing to do with it. So in order to get that kind of housing in, we're gonna have to look at some other process.
Well, and I think,
Yes.
may I just say too, that I think that some of this has to do with financing for that particular type of housing. So many of those, that business mode relies on tax credits, and it is a very particular way in which they receive the funding from, federals or county, and there's timing involved, and those tend to be different. That's a specialization in the development industry. It isn't necessarily the same home builder who would have the experience in knowing how to fund some of those particular types of housing. So it's worth a larger conversation and some research. And I'm the first to admit that in my world, people come in with an affordable housing project like Marion Villas, like Linnea Villas. They're a different set of developers. They know how to wend their way through that financing system, and it's quite complicated. And not that a regular developer doesn't have their own challenges in terms of financing, but it's a different area of expertise.
It is, and trying to get the developers who are interested in single-family residence developments like the one we're looking at now and have seen come before us in the past few years. Apparently, they haven't been able to work out that problem because they've never been interested in putting any kind of multifamily housing in their single-family developments. So I'm back to just hang on. So I'm back to the mayor. Maybe nobody else has any interest in this, but I do. And I think that these single-family developments are a perfect opportunity before they get built out to put in a couple of duplexes or a couple of triplexes. And yes, I'm somewhat sympathetic to the financing problems that the developer has, but I'm not real sympathetic. Not to the point where I'm just going to say, okay, you can totally forget about building those ever. I'm not sympathetic to that point. They should be able to build something like that at some time, and we haven't had anything over the past few years. A couple of duplexes, how difficult could it be? A couple of triplexes, it provides a lower cost opportunity for people to get into a residential development that they don't have that choice now. I mean, and I look at the inclusionary housing section here. Wait a minute.
May I speak to a point?
Yeah.
I think what Paul's trying to go ahead and talk about, and what you're talking about, Holly, is they're different cats. What Paul is trying to talk about is having some duplexes, some spread within a single-family home development. And as Sandra has brought, as West Star has brought previously, when you start looking at marketing and what the buyers want, most buyers who are looking at single-family homes do not want to live next to a duplex or a triplex community, which is why you have the triplex, duplex at the fringes of a single-family residence, and that's a market effect. And a developer on a 20-acre parcel has to be careful about making sure that his project sells. Now, if you had an 80-acre parcel where you're putting in a master plan, and some of our larger cities, but Kingsburg has never been a town where we've been approached by a developer that wants to put in an 80-acre or 120-acre development, because it just doesn't sell in a timely and an economically practical manner. So what Paul's talking about, this inclusionary housing if you look over at Pheasant Grove, which was built in 2000, when was that built, Sandra?
Actually, it's like
Anyway, make a long story short, that has some duplexes and triplexes on the fringes of it, but in the interiors, all single-family homes. And so that's, like I say, that's a whole different way of developing. And in the North Kingsburg specific plan, we really don't have a good mechanism to go ahead and encourage that.
So, I hope everybody doesn't think that because we build mainly single-family residential homes, that that's all people really want to buy. No. There are lots of people out there looking for a little lower-cost housing opportunity, such as a duplex or a triplex inside of a nice residential area. Sure, they want to live there. They don't have $600,000 to buy a house, but they would like to live in that neighborhood. They can't live in the neighborhood if there's nothing for them to afford. So a couple of duplexes and triplexes is not going to break the back of a developer who's putting in, 150 units. They won't build it voluntarily. We already found that out because they're not interested in the allocations. So what's the next step? The next step is a requirement. If you want to, and I take this back to the mayor because the people who are going to make that requirement are in city council, not here. So I'm going to put this idea into your head because I brought this up before, and the thought that you can't build a triplex because you won't be able to sell the house next to the triplex, well, I'm not buying that because there are residential areas where people buy next to the triplex. In fact, the design of duplexes and triplex now has gotten to such a perfection where you can drive down a street and drive past a triplex. You'll never know it because it's designed in such a way that it looks like a single-family home. And there are just redundant examples of how this is done. Even apartments, there's some 6 or 7 unit apartments. They make them look like single-family homes, so when you drive down the street, you don't even know it. So I don't think we should eliminate that opportunity for people to get into those lower cost duplexes and triplexes because the developer might have a hard time selling the house next to it. Well, that's going to be his problem, I guess. I don't think it automatically becomes our problem that we need to solve for the developer just because he might have a little trouble selling that house next to the duplex. What we're supposed to do is provide the opportunity for people to get those living arrangements, not to solve all the problems for the developer in selling the house. So, Mr. Mayor, I don't know if anybody else has any interest, but I do, and I think that we could get that done in Kingsburg, but it's going to be up to City Council to draft some type of municipal code change to say, hey, and you could make it part of the allocation process somehow. Hey, you want to put in 120 single-family units? You're going to have to put in, 10% duplexes or triplexes. It's the only way you're going to get them in. Otherwise, they're not going in. So, the next thing I want to discuss was the infrastructure. And the infrastructure, which of course is the...
Commissioner, I think she has a question for you.
Oh, I'm sorry. I forgot all about you. Yes, go ahead.
May I just speak in regards to
Yeah, sure.
inclusionary? And only because now I'm going to show my age, and I apologize, I've been around for a few moons. In 2005, we built a project on the west side, Sierra Ranch, wonderful project, had a fire station dedicated, a number of things. Our first plan included a number of single-family homes, triplexes. We had resistance. We fought against the resistance and put in the multifamily homes and the triplexes, and they're wonderful. And you're right, there is a great curb appeal. It's come a long way. In 2008, we pushed it a little further and brought our 80-acre master plan. Inclusionary was a big word for us. We had a mixed use, multi-generational. We were, I felt, way ahead of our time.
Was that the one on?
North of Cam.
Yeah, I remember that. What happened to that? We were all,
There
remember
was
the plans just-
pitchforks and people standing outside telling us there was no way we were gonna build in Kingsburg.
Because the planning commission.
We are completely and utterly capable of building what needs to be built. And we will bring it. We can't fight against the ones,
No, let me.
so that's
Mr.
our
Williams
challenge.
here, I don't remember a lot of pushback from the planning commission. The planning commission was in favor.
Oh, no, there was major public
Uproar.
sentiment against, because you even had a condo complex.
Complex and a senior living
Yeah, in that
gated community.
very
We
nice.
were very excited about how
And-
that was and what that was gonna bring to Kingsburg.
And it scored high,
It
but
did.
they had to withdraw it because of the fact there was so much negative publicity. In fact, there was a rumor, if I remember correctly, that'll be Section 8 housing.
Yes.
That'll be low-income housing.
And
And-
I will commit to you, because that's a totally different topic, but we are up for the challenge. We're not afraid of selling the product at all, because we know the needs there. We have multi-generational, the kids want to come back and live where their parents were. There's need for that. It's bringing it and having it accepted is going to be the challenge for everyone.
Maybe we shouldn't do 80 acres.
We did
just
40, we did
40.
20, we did,
Maybe
we
don't
tried
do-
everything.
Maybe don't do it in 20 acres, just put in 2 or 3 duplexes.
It's gotta sell.
And we're okay with that. At this point, I can't really change anything, but we have been in discussions with the staff, we're open to a number of design aspects of it, so.
Okay, I'm gonna throw it to the mayor.
That's-
Mr. Mayor?
And staff
I just
is,
want to throw that in, I
Yeah.
just want to throw
No, I
that in
understand.
because we've been, we're
Yeah.
here to
Yeah,
try to figure it out.
You have to get the perfect equation for it to go. But, Mr. Mayor, it's not gonna ever happen unless there's some push, or there's some mandate from the city to build it. It's just not ever gonna happen, in my opinion. So.
Been there, done that.
But I appreciate that.
Good luck.
Maybe it needs to be a ballot measure.
Okay, I want to go to infrastructure and services. And again, it doesn't look like the points really matter a lot, but the discussion's important. So infrastructure has to do with the map, and I look at the map, and I see. On the south end, well, first of all, let me talk about Planning 101. Planning 101 means that all residential neighborhoods have to have interconnectability. They have to interconnect. When you build one neighborhood, it has to interconnect with the next, and the one on the east, and the north, and the west, and the south. They have to interconnect so that people can walk from one neighborhood to the other, or ride their bike, or even drive through. It is never a good idea to build any kind of project or neighborhood where there's no interconnectivity. It's almost tantamount to, what do they call them, when they put a wall around? Gated communities, just like having, separate gated communities all next to each other when they don't interconnect. So when you look at this map, there's interconnection with the community to the south because 14th and 17th were already there. They were forced to interconnect with, get my glasses on, 14th and 17th to the south. They were forced to interconnect with those roads because those roads were put in with a north-south planning interconnectivity into this new neighborhood. The problem with this is there's no interconnectivity between this project and the next neighborhood going to the north. There's no interconnectivity with this project and the next neighborhood going to the west. It's not there. Now, there's two arguments that come up. Well, just let the developer build whatever he wants. Or the other argument is there has to be interconnectivity between all the neighborhoods. So, and it's not just for a pedestrian experience. There has to be a traffic flow. So now you have a traffic flow, a proper traffic flow from the neighborhood to the south, because 14th and 17th are gonna connect, but 14th and 17th die on the north end of this project. They don't go anywhere. They're not gonna continue north, 14th and 17th die right here. What is it called? There's a street here, it's got a cul-de-sac on one end, there's a cul-de-sac on the west end.
It doesn't have a name. The street
Doesn't
doesn't
have
have a name. There's no name on the street.
If you want interconnectivity with the future neighborhood to the west, then that cul-de-sac should not be there. It should be a stub street, ready to go into the next neighborhood, at least for that one. Now, you also have, this is an L-shaped property, and underneath the arm of the L is gonna be another neighborhood, and there's no interconnectivity between that and this neighborhood. So infrastructure, 0 points in my mind. They haven't provided what, in my opinion, would be a very efficient, very functional structure to interconnect the future neighborhoods. And I can tell you exactly why they do that. But, so as far as infrastructure, for me, 0 points until I fix that problem. Would you like to?
Can I just make a couple of comments here? I hear what you're saying, first of all, and for this submittal for allocations, the requirement is a conceptual map. It really doesn't even rise to the level of what will be coming to you in its final form. I also know that Westar is busy finishing other neighborhoods, and this is still internal staff discussion, pretty elementary at this point, pretty premature. And the North Kingsburg specific plan has been very clear about connectivity, pedestrian, friendly design. And those, we are definitely taking that to heart, and we will be continuing to make that a priority as we look at this map. So as you see this map here today, it is for illustrative purposes for this particular action, right? But not in any way the final map that we will be working on, and then you will see.
All right, I'm happy to hear you say that. The only problem is he wants 105 units, and if you drop this cul-de-sac for future extension west, he's going to lose 2 units. So does that affect our vote tonight? If we allocate 105 units, is that a flexible number in terms of future evaluation of the map? They can go down, but they just can't go up in terms of you ordering it. Whether they want to go down or not is another. And where they go down is a discussion to have with
So you're
staff.
saying we'll have a more finalized map to discuss later?
Yes, in due time. To be frank, they're quite busy with the current projects, and this is still in a conceptual stage. They've decided to go forward with this at this time for allocations. That's their choice. It does put them on a bit of a time frame to work with us. But because they need annexation, they get a little more time on this end, as opposed to whether if this property had been in the city, they wouldn't have. They would have a year, but as it is, they have 24 months. So.
And just to reinforce that point, this same situation occurred in the original Nelson subdivision that was on the south side of Cam. And it started out as a larger number, and through combinations and changes and allocations, the allocations never went up, they actually went down of what was actually built.
If they wanted to go up, they would have to restart the process. It would not be granted. We wouldn't be able to come back and add 5 more next year or something like that. It would be a new application.
So clarify for me, how many allocations do we allow a year?
We allow 115. Now, there is some rolling allocations now, so there are actually more in the pool, in the pool that's been, you know, there's been some rolling allocations. I know that is a little confusing, but at this time, there are more allocations than the 105 that are being, or 115 for that matter. So,
Okay, so is that the allocation, I don't understand some of this. The allocation, is that for the development? Or is that for the city?
that's a total for the city.
Okay,
Per year.
Okay.
So there are 85 single family and 100 and, 35 for multifamily. And there are excess allocations at this point because there were several years where no allocations
Right.
were granted. So
okay. So
that's where
if
we
a-
get to today.
So if someone comes in and wants to do 115 houses, that's it for the whole year, right?
Well, the timing is such that they may get a second chance if a second round of allocations is opened in the spring, and that is a council decision.
Okay.
So the timing is in the ordinance. The timing was, on October 30th at 4 p.m. Applications are due, and it literally says that in the ordinance. And then, whoever gets it in is being considered. Their application will be reviewed, ranked, and those are the allocations that are given for that time period.
So,
It's a cumulative thing.
yeah, I understand that. So if four groups come in with 100, each of them want 115, then it depends on the points that you come up with.
That
right?
would be the
Primarily.
process.
Okay.
That would be
I
the
just-
process.
Clarification,
Yes.
thank you.
Mhm.
Yeah, I understand that.
Yeah, we haven't had people come in.
For a long time. Yeah. Probably never will.
All right, then, anybody else have any other questions about the proposal before us? The request for allocation of housing units, any other questions from staff? Any other comments? All right. In that case, this resolution is 2023 dash
Don't you have to close the public hearing?
03? This wasn't a public hearing.
No, we have to make a determination that the environmental,
I don't see that either.
I think we're just simply talking about approving the number of allocations. I don't think any other particulars are included in that.
Sequel? I don't see sequel.
Dr. Cooper, Chair Cooper, it is exempt from CEQA, so the determination, environmental determination doesn't need to be made.
Single-family development. Oh, okay. Recommendation. Single-family development.
don't we have to go ahead and make the recommend the city council approve the environmental determination that the award of the housing units is a project under the CEQA Act pursuant to guidelines?
Mr. Nolan, I think it's just the resolution we're after tonight, isn't it?
You're making recommendations to the city council that city council ultimately awards the allocations. So you're making on page 2, the recommendations are to recommend to the city council that the project is not that the award of housing units is not a project under CEQA and is therefore exempt. And then the second, so you have one motion for that recommendation, and your second motion is to recommend that the council award the 105 units, housing units, as the 2023 housing unit allocation to West Star Construction.
So I'll entertain a motion on the first item.
So move.
I'll second it.
Review the reading.
Yeah, page 3. The backside of what you're looking at then.
So we have a motion and a second to recommend to the city council that they approve the environmental determination that the award of housing units is not a project under the California Environmental Quality Act. We have a motion and a second. Any discussion or amendments? All in favor of that particular motion, say aye.
Aye.
All opposed, say no. Hearing none, that carries. The second part is,
To recommend to council that the,
To award the 105 housing units.
yes,
the second part is the resolution (2023.23) 03. 202303. So I'll entertain a motion to approve resolution 2023-03. Recommend to the city council the annual award of allocations.
I so move.
I'll second.
So we have a motion and a second to pass resolution 2023-03. Any discussion or amendments? None? Okay, call for the question then. All in favor of passing resolution 2023-03, say aye.
Aye.
All opposed, say no. So, the motion carries to pass resolution 2023-03. All right. What's next? Help me out, Holly. Number 5, City of Kingsburg project review and update.
Update, yes. Just very brief update on some of the projects around the city. And I wanted to also give you a little heads up as to what may be coming up for Planning Commission review and consideration. So you're probably, thank you. You're probably familiar with the Bull Bistro down the street that's near Fugazi's. That's a small takeout restaurant, and that will be, it's getting its health department review right now, and that's sort of one of the last steps so before they can open up for business. It's a takeaway type place, so it will not have seating, but rather simple salads and foods like that. And the investors behind that are also involved with Roadhouse, so that's a good thing for us. As you know, Morgan's is now closed after a number of years on Draper Street. They are in the process of identifying and working with an architect to draw up some conceptual plans, and I believe they may be headed for a restaurant type use, but that remains to be seen. The Arnst building has completed repairs inside, according to the satisfaction of the building official. They are apparently in discussions with several tenants. BLD building, the former BLD building, was, I think we mentioned before at the last meeting that it had been sold, and they are readying some submittals for site plan review. Quick Corner has gas and convenience store has been with us for a number of meetings. They have submitted some plans for a rebuild. Will look very similar in terms of uses to what they had before, and we've been taking them back internally for discussions about how they can meet some of the new standards that they need to now. Yes, Mr. Blaney.
entrance and exit, that's fairly close to the intersection. Is that going to be grandfathered in?
I believe so. I think it's been reviewed by the city engineer, and I think that also Caltrans needs to be involved with that too. So Caltrans will weigh in if they feel that's appropriate. But at this time, the plans seem to indicate that the entrances and the exits will be the same. They will be red curbing some of the internal curbs, though, because apparently that was an issue at times where people would park and in sort of random places on that side. So we're hoping to straighten that out a little bit.
Holly, does that project, before you walk away from it, does it include a restaurant like it has in the past?
Yes, it will include a restaurant and then also a takeout place. So it's very similar to what was
So dimensionally about the same as what he had before?
dimensionally the same, yes. Yeah, we worked quite a bit with the applicant to see if that's really what their vision was, but he's pretty determined that that's really what he wants to see go back. It will be there will be a rebranded as a golf station. I don't know if you're familiar with the golf stations, but they are up in the metro areas. And
It used to be here 50 years ago.
I guess it's back. So, I think you might have noticed that Brew Wings has has shut their doors, and I believe that they are considering a number of new tenants at this point. One of the tasks that we have in front of us, that again, it's sort of an unfunded mandate from our friends at the state at Sacramento, has been the requirement to develop an ADU program. And some of that program should include plans that we can offer the public. That will involve a number of actions, including consultation with you all. And I would look forward to that discussion with you as we start to narrow down some of those options and figure out what we can and can't require in terms of ADUs. I think it's conceptually a good idea, but again, an unfunded mandate where if we have architecturally approved plans and that have basically been vetted by building code also, that's going to cost us a little money to either purchase or have drawn up. So I would welcome that conversation from you as your interest in design, to see what we can do to create a small play deck for Kingsburg that would be appropriate for our different building styles, and that would hopefully fit sort of the spirit of the town too. So that's a project that AJ O'Connell, building official, and I are working on, and he has Carol digging up ADU images from the computer pretty much every day these days. So we'll try to dust that off and bring that to you, I think, towards the beginning of next year. You'll probably also see the Quick Corner conditional use permit come as soon as they end up getting to the point where their site plan review is in good enough shape to bring forward.
Who's that?
Quick Corner, the gas station.
Okay.
Will come to you as a conditional use permit.
Okay.
It's required to be to have a conditional use permit for that use in that location. So I believe that concludes my summaries. There is there's some interest expressed in Planning Commissioners Academy, which will be in Long Beach this year, March 6th through the 8th. I'm in discussions with the city manager about a budget for that. I don't believe I could probably afford to take all of you, but if there are people who are keenly interested in going, let's have a conversation about that, and we can see what we can do. Again, that's March 6th through 8th, and I know some of the people who are teaching there. It should be quite informative. So that concludes staff's update. Thank you.
Thank you. Adjourn. Well, we're going to adjourn the meeting. I'll take this opportunity to entertain a motion to adjourn.
So moved.
Second.
Second.
All in favor, say aye. Aye.
Aye.
Thank you. The meeting's adjourned.
Thank you.
You guys can just turn on your.
Thank you, Carol.